Dear students, good morning. Well, this is the lecture number 5 or even 6 on private international law. Well, in the previous lecture, we were naming the subject matters of private international law, and we reached the subject matter number 5, the nationality. And I've told you that I'm going to give you um, like a quick brief on nationality in this regard, simply because the nationality would be the stone or even the core subject matter of this course that I'm teaching now. So, what is the nationality and what are the problems of the nationality and how we can solve them? Then this would be illustrated, inshallah, in the near future. However, now I'm going to tell you that the jurists who belong to the Latin states or the Latin system, Latin legal system, so the Latin rooted jurists of private international law, they consider that the private international law subject matters include the nationality as one of these subject matters. And they consider it as one of the most important subject matters simply because it differentiates between the person who is a foreigner and who is a national. So to differentiate between the nationals and the foreigners, we have to verify their nationality. So we can say that if there is, according to the verification process, a foreign and national in a relation, then in this case there would be possibility to have the problem of conflict of laws or even the conflict of jurisdictions. So if there is foreigner, there would be possibility to these conflicts, whether conflict of law or even conflict of jurisdictions. Okay. However, if we verified the nationality of the persons in the relation and we found out that both are nationals or all of the parties to this relation are nationals, then there would be no possibility for any conflict of laws or even any conflict of jurisdictions. So that's why we can say that the nationality is one of the preliminary matters according to which we can decide whether we have problems of private international law like the conflict of laws or conflict of jurisdictions. Let me give you an example here. If there is a conflict before a court where a person, a foreigner person, like Egyptian person who is living in France, he claims that he enjoys a certain right according to the French law while he is in France. So the judge before in the French court here shall make sure whether this person is a national or not, because he is if he claims that he's a foreigner while he is not, he is a French in this case, there would be no conflict of laws. However, if this person, after verification of his nationality, the court finds out that this person is a foreigner, then there would be a possibility for conflict of laws on these matters. So that's why we can say that the nationality is one of the most important matters regarding the private international law. Okay. Well, nationality in the Latin system, and actually this info which is shown here is just to tell you that the nationality is connected with some matters, some important matters in the state. Like nationality in the Latin system, it connects with the nationality of the person, okay, and his capability. So the nationality، موضوع الجنسية بشكل عام في النظام اللاتيني بيربط بين أو دائما ما يكون في ربط when talking about the nationality. There is connection between two important matters: the nationality of the person and his capability or even status. Like, for example, the age according to which the person is considered capable of rights and duties, or capable of all rights and duties and capable to conduct the deeds and activities، اللي هو السن القانوني يعني اللي وفقا له بيصير قادر على انه يكتسب الحقوق والالتزامات كافة، بالاضافة الى to conduct some activities or civil activities، انه يقوم ببعض التصرفات القانونية المدنية like sale, lease and everything. Okay. So in the Latin system, they considered that there is connection between the nationality and the capability or the status to decide on a matter of law, the conflict of laws. Thus, the nationality is also a preliminary matter that is important to decide on the matter of laws conflict. So, for example, there is a person and this person conducted a sale, for example. Now, the judge wants to know, because this is a foreigner person, wants to know whether this sale is allowed according to the law of this person, nationality, or not. Like, for example, he's Egyptian or Palestinian, and this Palestinian person was living in, for example, in France, and he conducted a contract of sale. Now, there was a conflict between the parties to the relation, I mean, the seller and the buyer, and the conflict was brought before the judge in the French court. So, one of the most important things here is to detect whether the persons to this relation are capable to conduct the sale itself. So the judge in this case has to verify the capability according to every party to this relation. So when he comes to verify this matter regarding the Palestinian party, he would verify whether this person is capable or not. According to what? According to the law that is applied in his state. How to know what the state that he belongs to? Through the nationality that he enjoys. So when he finds him enjoys the Palestinian nationality, he will go to the Palestinian law. So the nationality led the judge to the Palestinian law. According to the Palestinian law, the person is capable to conduct the contract of sale when he is 18. So if he found that this person is 18, then it's okay. He's capable to conduct such contract. However, if he is 17, he would rule that this person is not capable even to conduct the contract of sale, and the contract of sale in this case is invalid. Or let's say that it is null because one of the elements is not met. Okay? So look, the capability here is connected with the nationality. Simply, the nationality would lead me to the capable law or the applicable law. Nationality, Palestinian nationality, leads me to the Palestinian law. According to the Palestinian law, I decided whether the person was capable or not capable. Okay, that's why in the Latin system, they depend on the nationality in deciding matters related to capability and the marital status and whatsoever. Okay, even in the Anglo-Saxonian countries, they do not connect the matters of capability and status with the nationality. They connect the capability and the status with the matter of domicile, not the matter of nationality. يعني خلينا نقول انه في دول النظام الانجلو ساكسوني بربطوش بين موضوع الاهليه وموضوع الناشوناليتي، بربطوه بموضوع الدوميسايل. يعني كاني بقول لك الاتي، ان هم لما بدهم يفحصوا يعني اذا كان الشخص اهل لابرام العقد ولا لا، بشوفوش قانون جنسيته، بشوفوا قانون موطنه الاصلي. فإذا كان الموطن اللي اعتاد الشخص على العيش فيه وفق التعريف اللي حنقوله للموطن فيما بعد، إنه موطنه الأصلي هو فرنسا، بيقولوا إذا والله القانون واجب التطبيق هو القانون الفرنسي. فبرجعوا للقانون الفرنسي بيلاقوا إنه الشخص لازم يكون عمره مثلا وفق سن الرشد 21 سنة. إذا لقوه أبرم العقد بعد ال 21 أو من لما كان 21 then the contract is valid. However, it is null if he contracted with the other person when he was under the age of 21. So the judge here depended on the domicile in deciding his age, I mean the person's age, and then to decide whether he is capable or not. لكن اللي بدنا نعرفه انه the nationality على الرغم من انه الانجلو ساكسونيين بيعتمدوا على الدوميسايل في هذه المسألة، الا انه في معلومة بتقول لي هنا the nationality deems important to decide on the matter on domicile itself. يعني هم بيعتبروا لي انه احيانا بتكون مسألة الناشوناليتي مهمة في تحديد مسألة الدوميسايل itself. So we can consider that the nationality, it is not only preliminary matter to decide on the matters of conflict of laws and conflict of jurisdictions. It is important to decide on the matter of domicile, and this is what we will illustrate later, inshallah. What matters here is to know that the nationality is preliminary matter for the other matters of private international law, like conflict of laws, conflict of jurisdictions, and even the domicile. Okay? Well, now let's move to another slide, the domicile. In brief, we previously showed that domicile regarding the Anglo-Saxonian system. It is the key point according to which the judge decides on the person's capability or even status. Thus, the domicile is important to decide after that on matters of jurisdiction and matters of conflict of laws. Like the example that I gave you before regarding the person who is, for example, Egyptian and he was in France, and the judge depend on the domicile, and when he found that the main domicile of that person is Egypt, then he shall seek the Egyptian law in deciding whether the person is was reaching the legal age or even he didn't like reach it. So that's why domicile is considered one of the private international law matters, and even the domicile is preliminary matter for the matters of jurisdiction and conflict of laws. Look, I told you that nationality is preliminary matter for domicile. Then domicile is preliminary matter for conflict of laws and conflict of jurisdiction. Even matter of jurisdiction cannot be decided without, or the conflict of laws cannot be decided unless we decide what is the competent court. That's why the matters of private international law are well connected to each other. مواضيع متشابكة. يعني أنا قاعد بقول لك إن الجنسية مهمة في تحديد الموطن أحيانا، والموطن بيساعدني في تحديد مسألة تنازع القوانين وتنازع الاختصاص القضائي، وحتى التنازع القوانين مش ممكن نحدده إلا لما نحل أول إشي مشكلة matter of jurisdiction. So they are thorny matters، مسائل متشابكة كتير، and they are well connected, well linked، مرتبطة ببعضها البعض. اوكي، يعني هذا كنت حابب اوضحه اليوم بخصوص هذا الموضوع. الآن خلينا ننتقل إلى مسألة مهمة، وهي عنوان محاضرتي في الحقيقة لهذا اليوم، وهي the sources of private international law. في الحقيقة أنا متشوق لبدء أول موضوع اللي هو موضوع الجنسية، وأنا بعتبر هذه كل الموضوعات موضوعات ما زالت تمهيدية، لكن أهم موضوع وأحلى موضوع راح يكون معنا لهذا الفصل is the nationality. So I'm actually so interested in this field. Well, it is not my area of interest. However, when navigating the sources regarding the private international law and the topic of nationality precisely, you will find it so amusing matter. That's why I am really longing to start illustrating the topic of the nationality. Well, Now, the sources of private international law. The sources of private international law. Well, it is kind of like astonishing thing to tell that despite the fact that private international law is a national law, treaties, they are considered a source for a national law. So it's kind of irony. Not irony سخافة, irony بمعنى المفارقة المنطقية يعني. So it is a national law, private international law is a national law, and we call it international. I told you why, because it's not international law like public international law, or it is between states. I told you the reason why we name it international. It is because it has different nationalities. So private international law, it's a national law. However, treaties are considered a main source of private international law. So how come? Well, actually, there was kind of tries that were made by states to unify the sources of private international law regarding certain matters, simply because they resulted in a lot of international problems. يعني في موضوع الجنسية على سبيل المثال، موضوع عمل مشكلات كبيرة على الصعيد الدولي. خلينا نقول مسألة المالتي ناشوناليتيز، مسألة تعدد الجنسيات، مسألة آه انعدام الجنسية. كل هذه المسائل خلت الدول تبحث عن توحيد لأسس كسب الجنسية وفقدها ومنحها. فراحوا حاولوا يعملوا اتفاقيات دولية زي مثلا محاولتهم على 1930. فاكرين لما تحدثنا عن ال 1930 The Hague Conference regarding the International Law of Sea. في الحقيقة هذاك المؤتمر ما كانش بيحكي بس عن موضوع ال International Law of Sea وموضوع ال Territorial Water. كان في 3 موضوعات على الأجندة. موضوع the laws of nationalities، قوانين الجنسيات، كان من أهم الموضوعات اللي كانت بتتناقش، وكانوا بيحاولوا إنه يحطوا اتفاقية موحدة تتكلم عن موضوع الجنسية، وحطوها بالفعل عام 1930. أما بالنسبة لموضوع المياه الإقليمية ففشل في هذاك الوقت، وهذا موضوع تكلمنا عنه سابقا. Okay? So treaties are considered the main source of private international law. That's why I gave it number 1. So treaties, according to the concept of traditional international law, are the agreement between 2 or more subjects of public international law, which aims at arranging the effect on international relations. So this is the definition that we took it before on the course Public International Law. As for the concept of the Vienna Convention on the Law of Treaties of 1969, it is a written agreement between 2 or more states which aims at arranging or creating a specific legal effect on an international topic. And this is according to Article 2, Paragraph A of the Vienna Convention, or the VLC, VCLT. Okay? So the treaties are maybe multilateral or even not bilateral. So the treaties may be bilateral ones, a source for private international law, or even it may be that the sources, the treaties are multilateral ones. Anyway, the treaties, as shown here, play a vital role in all matters of private international law, since the state needs treaties to regulate the affairs of all private international law issues, but their effect is direct in some issues such as conflict of laws, conflict of international jurisdiction, domicile, and status of foreigners, while it has indirect impact on nationality. That's to say, treaties influence the provisions of nationality through legislations only. معلومة مهمة هنا كتير. بيقول لي إن المعاهدات الدولية تعتبر مصادر القانون الدولي الخاص بدون مشكلة، ولأنه الدول كتير بتحتاج إنه يكون في معاهدات توحد لي المصادر لمسائل القانون الدولي العام أو subject matters في القانون الدولي العام. ومع ذلك treaties has different effect on the international subject matters of private international law. That's why the treaties has direct effect on some matters like conflict of laws, conflict of international jurisdiction, the conflict, the matter of the foreigner status. بقول لي هدول الموضوعات بتأثر بشكل كبير بالمعاهدات، لذلك المعاهدات بنقدر نقول بتأثر في هذه الموضوعات بشكل كبير، وممكن تحط قواعد مستقرة ومتبعة في كل دول العالم بدون إشكاليات. لكن احنا عارفين انه الدساتير بتقول انه موضوع الجنسية لا ينظم الا بقانون. معنى ذلك انه the main or the main source for nationality تحديدا is the legislation. يعني التشريع هو المصدر الرئيسي للناشوناليتي، وممكن نعتبر الانترناشونال agreements are sources for the nationality, but they are not direct sources, they are indirect sources. أما بنعتبرهم بالنسبة للجنسية موضوعات إيه؟ موضوع يعني بنعتبرها مصادر ثانوية غير مباشرة. ليش أنا بحكي هذا الكلام؟ الموضوع اللي بالدرجة الأولى ينظم بقانون من بين كل موضوعات القانون الدولي الخاص، مش تنازع القوانين ولا تنازع الاختصاص القضاء ولا غيره. هذول الموضوعات غالبا بنظمهم اتفاقيات دولية، في حين الموضوع اللي بيعتبر الفيصل في تحديده، أسس كسبه، منحه، فقدانه إلى آخره، الليجيسليشن، هو موضوع الجنسية، الناشوناليتي، هو الموضوع الفيصلي من بين كل موضوعات القانون الدولي الخاص اللي بيتم حكمه بواسطة الليجيسليشن بالدرجة الأولى. ليش بنعتبر الاتفاقيات مصدر ثانوي؟ أنا أقول لك ليش. Now, according to the constitution of every state, the legislation is considered the main source of the nationality. However, it's made that the state, for example, it ratifies the Hague Regulations 1930. ممكن تتوقع على أو تصدق على اتفاقية لاهاي عام 1930. Now, according to this ratification, according to the dualism system تحديدا مش المونيزم، بتصير legislation اللي حطته الدولة بخصوص الجنسية هو المين سورس. طب وبالنسبة للاتفاقية اللي انضمت إلها وتتحدث عن موضوعات الجنسية، بتصير the second source، وبتصير تطبق في الدولة ما لم تتعارض مع الليجيسليشن المحلي. عشان هيك عمالت أقول لك في الدواليزم سيستم، عشان انتوا يمكن مش متذكرين، فهحاول من الوايت بورد إن أبين المسألة. لو احنا كنا زمان نحكي عن الدواليزم وبنتكلم عن المونيزم. According to the dualism system, there are two laws, international and national. International and national. Now in the monism system, if the state ratifies a treaty regarding the nationality, this treaty would be considered immediately part of the national law. It's made according to the constitution itself explicitly. It states that when the state ratifies a treaty, it becomes part of the national law. It has the same power as the constitution, or even it is more powerful than the constitution. In this case, we can say that the treaty in the monism system is a main source of the nationality. It is the same as the legislation. ليش أنا بقول هذا الكلام؟ لأنه التريتي صارت جزء من القانون الداخلي مباشرة، بل هي تساوي الدستور في قيمته. ممكن تقول حسب النصوص الدستور تكون أعلى، ممكن تكون أدنى، في كل الأحوال هي أقوى من the law of the nationality which is a ordinary law. لأنه مش معقول الكونستيتيوشن نفسه يحكي عن الجنسية، الكونستيتيوشن بيقول تنظم الجنسية بقانون اللي مين بده يحطه؟ البارلمنت. فالبارلمنت لما بحط قانون للجنسية بنعتبره ordinary law، قانون عادي. التريتي لما بتصير جزء من القانون في نظام المونزم حتكون جزء من القانون، يا بتكون في نفس قوة الدستور، في بعض الدول بتعتبر نفس قوة الدستور، يا أقل من الدستور ولكن أعلى من القانون العادي. في كل الأحوال لما بتكون هي أقل من الدستور وأعلى من القانون العادي أو مساواة الدستور مباشرة، هل معقول أسميها إنه هي indirect source for the nationality؟ لا، هي direct source for the nationality. وين في إمكانية أني أقول عنها indirect source for the nationality؟ في إمكانية أتحدث عنها ك indirect source for the nationality في الدوليزم سيستم. ليش أنا بقول هذا الكلام؟ ليش أنا بقول هذا الكلام؟ بقوله لأنه في الدوليزم سيستم الانضمام للمعاهدة بخليهاش جزء مباشر من القانون الوطني، وإنما تحتاج لإجراءات معينة. مش بس هيك، في حال وجود التعارض نطبق the nationality law and we will not apply the treaty. So the treaty here mustn't violate the national law of the nationality. That's why we consider that the nationality treaty here is considered an indirect source for the nationality matter as one of the subject matters of private international law in the dualism system. So there is difference between the monism and dualism, and you have to be careful when dealing with my questions regarding this point. Okay, you have to differentiate between these two important matters. Okay, let's be back to our lecture. Okay, for example, the convention of CEDAW، يعني كإحدى الاتفاقيات، اتفاقية سيداو القضاء على أشكال التمييز ضد المرأة. الحقيقة أن اتفاقية سيداو القارئ لها بيجد أنه بعض النصوص كانت تتحدث عن الناشوناليتي of the woman. يعني it's made that in some countries when a woman is engaged or even married to a foreigner person, she loses her nationality and she acquires the nationality of her husband. According to the law and her husband's law of nationality, if she got divorced, okay, if she gets divorced, then in this case she loses the nationality of her husband. The same time, she loses her original nationality and she becomes in this case without a nationality. So this is a problem. So CEDAW actually was talking about the matters of the nationality of these women who lose their nationality because of such matters like marriage and divorce. So Iraq, for example, it ratified the CEDAW, and CEDAW, it has indirect like effect on the matter of the nationality and the law of the nationality number 26 of 2006. So simply because the Iraqi system is a monism system, it adopts the monism idea, and the treaty must be given priority over the ordinary law or the national law of nationality. The Iraqi state, it amended the law of nationality number 26 of 2006 to be familiar with the CEDAW. يعني في العراق لانه بيخدم نظام المونزم، والمونزم بقول لك انه بيكون القانون الدولي التريتي اعلى من القانون الداخلي، فلازم تجري تعديلات على قانونك الداخلي بما يتوائم مع الاتفاقيه. فراح القانون او قامت اللي هي السلطه التشريعيه العراقيه بتعديل القانون هذا بما ينسجم مع سيداو. ليه؟ لانه سيداو اعلى مرتبه. ولاحظ انه التعديل كان بمس مين؟ قانون الجنسية. That's why we can consider that the treaty here has direct effect on the law of the nationality. It has direct, sorry, not indirect. Direct because it is the concept of monism that the Iraqi constitution adopts. Okay. Well, the state here may accede to multilateral agreements of or treaties that regulate matters of private international law. For example, the Geneva Convention of 1952 is considered one of the multilateral treaties which talks about the subject matters of private international law. It is called the Universal Copyrights, okay? So the Geneva Convention on the Universal Copyrights 1952, one of the multilateral treaties which addresses the private international law matters. Also, states are allowed also to conclude bilateral treaties on one of the issues of private international law. For example, the US, for example, it has concluded many bilateral treaties where the number of countries concerning the consular matters, because the consular matters is considered one of private international law matters. You can read about these bilateral matters here. So if you just click here, it is هايبر لينك، يعني ارتباط تشعب، لو انت ضغطت عليه ممكن يحولك مباشرة انت من عندك في شرايح الباوربوينت للاتفاقيات الثنائية اللي ابرمتها الولايات المتحدة الامريكية مع كثير من الدول في مجال الconsular matter and private international law matter. Also, Iraq and Syria have bilateral treaties on the legal status of the foreigners. This is an example for one of the U.S. treaties, which is concluded with Albania regarding the consular matters. And also some multilateral treaties that affect on private international law matters. Here is examples for multilateral treaties which affect on private international law matters. The Riyadh Agreement of 1983, it talks about the conflict of jurisdictions and enforcing the foreign decisions. These are two main subject matters of private international law. They were regulated in a multilateral treaty named the Riyadh Agreement of 1983. Don't save them, they're just an example. Vienna Convention on the Diplomatic Relations 1961, it is considered one of the treaties which talks about the conflict of jurisdictions and enforcing the foreign decisions. Havana Agreement 1980, 1958, it has another name actually, Postmanti Group, مجموعة البوستمانتي، واللي بتتحدث عن the status of the foreigners. Well, I will not take this topic for this day. I may postpone it for another day, inshallah. We will talk about it in the second, in another lecture in the future. So these sources, I mean, the custom, the international judiciary and jurisprudence, we will discuss them later, plus the nationality. Then, inshallah, I think after 2 lectures or less than 2 lectures, we will start our new topic, which is the nationality. Okay. Thank you very much. And I will see you, inshallah, in the coming lecture. Thank you very much and goodbye.